Streaming live via the internet. Welcome to ISP Radio, your weekly source for ISP-related news, events, and interviews with industry experts. If you deliver internet via fiber optic, wireless, coax, or any other way, you're in the right place. Chat live with us weekly via ispradio.com every Wednesday at 11 a.m. Central Time. And now a brief word from our sponsors. Link Technology, providing ISP consulting, support, and hardware for wireless ISPs. TowerCoverage.com, providing online RF coverage maps. Mimosa Networks, providing high-density, high-bandwidth radio products. Advanced LLC, providing retail and wholesale advanced communication services by matching providers with your bandwidth needs. And by Sitel, providing reliability in surge suppression. And now your host for ISP Radio, Steve Grabiel and Dennis Burgess.
Welcome to another edition of ISP Radio. I'm your host, Steve Grabiel, broadcasting from the home office in Southern California. And I've got Dennis Burgess producing the show from St. Louis, Missouri, and co-host as well. Well, had no show last week. I hope everyone had a great New Year's. After our show the day before Christmas out in New Mexico, we got hammered with like 3 feet of snow. And fortunately, through all the hard work we did through last year, the network seemed to run pretty darn well, sans some batteries that hadn't been charged for a few days because of the intense cloud cover and snowstorm. But other than that, we got through it pretty well and continue to operate at full capacity now out in New Mexico. And out here in Southern California, we've been going through some rainstorms. Had a pretty good rainstorm yesterday, and we're supposed to get hammered again out here today. So we're out in California, Southern California. It's chilly. When it gets down to about 60 degrees, it gets darn cold out here, but nothing like it is around the other parts of the country. Dennis, did you have a good New Year's, and did you guys survive all the storms?
Yeah, the storms. I don't know about that. I'll tell you what, we had so much rain, I just don't know what to do. We had, right after Christmas, we had like 3 days of just pour down rain, and this was actually the worst flooding in St. Louis on record. So definitely really bad. We actually had at one point in time some of the news guys, weather guys on TV came on and said basically pick a side of the river, the Merrimack, and pick a side, which side you want to be on in the morning, because either you need to get there now or you're not going to get there in the morning. So in our case, we have a number of highways coming out of the city of St. Louis from downtown. Basically, the big ones coming down south is Highway 55 and 44. These are both interstates. Both of those were closed completely. For 44 was closed for actually I think like 3 days, and 55 was closed for about a day and a half. And then we look at other bridges that come over the Merrimack going south. Highway 21, Highway 30, both were closed for 3 or 4 days at a time. And 61, 67 was closed for a while. So really, you only had we ended up with only one new bridge, Telegraph, which is not a big bridge. When I mean not a big bridge, we're talking like 2 lanes. For all of the traffic that normally comes south into downtown or into St. Louis during rush hour, it just didn't work out so well. They basically said if you had to go there, don't. So we definitely had a lot, but as far as networks go, things like that, it just rain doesn't really affect us too terribly much. The big problem we had is that it's cold. So we had all this rain, and it was 38, 39, 34 at night, 32 at night, sometimes a little colder. So all these emergency responders, MoDOT, and the police officers and all this stuff had to be out there in wet and cold conditions. I kind of feel sorry. I feel bad for them. A lot of people that have never been flooded were flooded this time. So, there's a lot of generosity going around right now. A lot of people, a lot of clothing drives and canned food drives and things like that, trying to get everybody back up on their feet. But that really all came about New Year's Eve in the next 2 days. So, whenever we look at it, a lot of places were closed. A lot of businesses were closed over New Year's. So it didn't impact. We did not have the traffic level that most people would assume we would have had, or we would have had if everything was open. But otherwise, really busy. It's a brand new year. Everybody gets their new budgets or are working on finalizing their budgets. So we definitely get a lot of customers and a lot of businesses that are getting ready to start projects, that are starting to order hardware, saying, hey, we need this, hey, we need that. We have a lot of interest in our Telrad gear. People have been quoting, and now they got their new budgets. New budget for the new year says, hey, let's go out and get the hardware and start installing. So that's really good stuff as well. And of course, we have all of our other products that we service, both service, consulting, support. So, good start for the year. How's that?
Yeah, it sounds like you guys are taking off the year with a bang.
Yeah, I mean, we don't want to slow down, and usually the holidays are routinely slower, simply because guess what? Nobody wants to work on the holidays. They don't want to work through Thanksgiving or Christmas. They don't want to make a network change and then have alarms go off, the next day on Christmas Day. So we get a lot of people that basically don't do anything, and then we get a lot of people right after the new year, let's start all these projects that I haven't done yet. And that's kind of where we're at now, which is a good thing, and there's definitely not a problem with that. We have some really cool projects as well that we get to work on.
Excellent. Yeah, you mentioned about the closed roads and stuff. After that Christmas on that 3-foot snowstorm, they had closed the interstate in New Mexico from Albuquerque all the way to the Texas line. Just too many wrecks and stuff. So just amazing the storms coming through. And what we received out here yesterday and what we're getting today is any indication, you guys are next in line for some more stuff coming your way. So be prepared. Yeah,
they're saying that we're supposed to get some weather this weekend, which kind of stinks, but that's okay. In St. Louis, we don't get that much snow. We probably get overnight we'll get 6 or 10 inches at the most. 14 is out of the norm, so a foot is out of the norm. Usually 2 or 3 inches, maybe 4 inches, and then the next day it warms back up to 40 or 50 degrees. So anything that's been plowed off has already melted away. And all you're really left with is all the nasties. But the difference here in St. Louis is that in the morning you can go out and there's snow on the ground, a fresh 2 inches of snow, and by the afternoon it can be 75 degrees. Now you need shorts and a t-shirt. So we get the St. Louis, we don't get a whole lot of really, really hot days, and we don't get a whole lot of really, really cold and wintry days, but we do get all 4 seasons sometimes in one day, is what they usually say. So it's not too terribly bad. It's not a bad place. How's that?
Yeah. So is there any news out there since we've been gone for a week and we did not do our show last week? Any news on the news front that we need to be aware of?
Yeah, not a whole lot going on. We're still waiting for the ruling on the open internet argument, all that kind of good stuff. There's definitely been some action with T-Mobile doing this unlimited video stream for participating systems, and they're basically stating that they're singling out various people who wish to be part of it, and then they transform the video in some way or modify the video, and they're saying that shouldn't be allowed. Definitely some weird stuff out there, and there's definitely some compliance issues. We've definitely had some calls from customers, and in our best estimate, I mean, we kind of have to turn them to a lawyer because they're asking these questions, can I sit there and block BitTorrent? Can I sit there and block, even YouTube or let's say Netflix on my network? Can I literally block that and tell users, when you buy my service, in my terms and conditions, you note that you do not have access to that? Is that legal? And it's kind of up in the air right now. I think people can say that the arguments can be made for both directions. Is it reasonable? The problem is that nobody's sat there and been ruled on and said what is reasonable or not. So I think the big problem is that it says technical reasons, and I do know some WISPs that have older radios and older gear, and they're trying to extend the life of those so that they're trying to prevent streaming video, things like that. And because of that, they're wanting to block that. And the question is can they block that? Can they notify the user? Can they block it? And is that legal? Because, hey, we have limited amounts of bandwidth, and we already have congestion, and this is a major source of congestion. But the problem is if you block YouTube or Netflix, what about HBO Go? What about all these other video services? You see what I'm saying? So the problem that kind of goes back to, hey, there can't be any preference of traffic. Well, you are preferring traffic. You're explicitly blocking some. So can you do that? And it's the same thing with BitTorrent. Is BitTorrent really something you can block? Now, you can unblock unencrypted connections. You can limit number of connections, things like that. But if you're specifically detailing BitTorrent, I use BitTorrent all the time to download ISOs and things like that. So there are legitimate usages for it. And because of that, how can you claim it as being reasonable network management? So, I think all those arguments, all that kind of thing is still up in the air. We're not going to see those until the FCC starts trying to rule on them. And my assumption is most of the smaller providers are going to get away with a lot to begin with. But they need to be focused, and they need to be aware of any of these rulings that do come down. So if someone does go to the FCC and say, I need a ruling, and the FCC makes a ruling, they need to be aware of what their system is doing and how those rulings will affect. Because until we get those rulings, I don't think anybody can say with any certainty what is or is not. It's all in the eye of the beholder, and everybody can make an argument until the FCC or somebody, a ruling party actually says, here's what it is. The rules are just too, how can I put it, open, not defined enough yet. And what's going to happen is they're going to have lawsuits. They're going to have these notice of actions, and the FCC will eventually say, no, this particular action was legal or not legal, or is allowed or not allowed, and then we'll have to start modifying. But we haven't seen those yet. So as far as legal news, that's probably the big thing. Yahoo kind of going under. There's definitely been some churn in the big companies, but other than that, not a whole lot of new products out there. I'm sure everybody's waiting for WISP America or other places to get those.
Right. Well, your discussion there segues us perfectly into our guest on the show today. Today we have Bob Silverman with Bennet Bennet out of Maryland. Bob's an associate attorney there, and I met Bob at the Wispalooza show, and he was on a panel at Wispalooza talking about basically what you just talked about, Dennis, open internet and that kind of thing. But Bob has a little bit different twist on this from his where he comes from. So, Bob, are you there?
I'm here.
All right, Bob, can you start off and tell us about, we talked earlier in before the show about where you guys are and who you represent and how it dovetails interestingly into our industry, the small ISP WISPs. Can you just go into Bob Silverman and Bennet Bennet?
Yep. Well, thanks, guys, for having me. Our firm is kind of a boutique telecommunications firm that generally represents rural telephone companies. Many of them have had their start back in the early telephone days, establishing themselves in their rural communities, often family-owned businesses or cooperatives. And most of our clients did go for the wireless play, generally starting in the cellular days of the 90s, and that's where we've really been counseling them, is into the world of wireless, mobile wireless regulation, mainly for voice. And then, of course, lately they've, everyone is upgrading their technologies and moving into these current heydays of mobile broadband. So that's really where things dovetail with the world of WISPs, except, of course, our clientele generally has been more accustomed to the world of regulation. So there's a bit of a different perspective there, but definitely plenty of overlap, as our clients and many WISPs are starting to do a lot of the same things and starting to carry same types of traffic, and this is where the FCC is starting to come in and saying we recognize this, and we think, well, we the FCC think regulatory action is necessary, and that's where we find ourselves. And that's why I was present at WISPapalooza, and I was grateful for the invitation. I sat with several other members representing other parts of the industry, U.S. Telecom, who, along with WISPA, has been part of the appeal of the Open Internet Order, and so several other attorneys. And we had a fairly broad-based discussion, both on the highlights of the order and also sort of the general impact of the reclassification of broadband internet access service as a Title II telecommunications service. So that's generally what I'll be doing here, is sort of reiterating the subject matter of the panel, but also bringing in some new updates. Obviously, you referenced the oral argument of the appeal, and I was also glad you mentioned this T-Mobile binge-on video service, because that has definitely come into play or gotten the spotlight put on them with an open internet or net neutrality lens. And so I'll be sort of going through that presentation again, but we can sort of pause and discuss certain topics that are most relevant.
No, absolutely. So tear into it. Tell us about, basically we're going over the same information with some new information, obviously, from the panel that you participated in at WISPalooza. But go ahead and tell us all things from the rural telephone side, how it's affecting you guys and how it can dovetail into what we're, as WISPs, are going through.
Sure. Of course, as a lawyer, I'll begin the way the panel begun, which was populated by lawyers, and with a quick disclaimer, basically that none of this sort of discussion or presentation is to be considered legal advice. There's no attorney-client relationship created. Reliance on the information is taken at your own risk, and that basically, if you have any particular issues or specific questions, we recommend you consult your regulatory attorney. And that's actually something that's going to sort of become present sort of as we discuss this, is that there will be several issues that really pop out and are of most interest to people, and you could really have a show about any one of those particular topics. So
right.
That's what really makes this interesting and difficult at the same time, because this order really just sort of aimed a whole bunch of arrows at a lot of different subject areas, and everyone has a different path, and I would love to be expert in every single one of them, but that's just not possible. But looking at the order, you'll recall that we're getting on almost the year anniversary of the adoption of the order. It was adopted on February 26, 2015, on a 3-2 party line vote. And you'll recall maybe a year ago the universe we were in terms of anticipating the open internet order. There were millions of commenters who had swarmed the FCC's comment system, with a lot of help from John Oliver and his discussion of net neutrality on his show. And almost a year ago, President Obama, supplied his own commentary on net neutrality, and arguably that influenced the direction of the order as well. And so that's where we were about a year ago, and now here we are wondering what's going to happen with the appeal of the order. The rules became effective on June 12th of 2015, all except for the enhanced transparency disclosure rule, just the enhanced parts. Those are still pending OMB, Office of Management and Budget approval. And I'll actually get into that because there's been some FCC action on that piece. Generally speaking, the order is divided into sort of 3 different parts. One is the order on remand, which is sort of the sequel to the FCC's actions in its previous open internet order from 2010 that brought it to the DC Circuit and led to the Verizon decision in 2014, where the court, though upholding certain pieces of that order, also said that the FCC was grounded in basically the wrong authority, that they couldn't put all their eggs in Section 706, which is sort of the best existing authority for the FCC, and that what they were really trying to do was reclassify broadband internet access service as a Title II communication service, and that's really what they needed to do to effectuate those rules that they had adopted. And so that's one piece of it. Another piece of it was the declaratory ruling, which is the piece that really did do the reclassification. And then there was also a forbearance order, which we'll get into, in which the FCC really gets into all the pieces of its regulatory regime that do and do not apply to broadband providers. Now, we discussed at the panel that this order has really become sort of a litmus test in a way, and that it isn't really necessarily all good or all bad, but it really depends on who you ask. A lot of, like, from a consumer point of view, they might see it as all good. From a business point of view, from particularly the largest cable broadband providers, clearly it's a lot all bad. And that, but that basically this order is intended to sort of set the stage and become more of a predictive regulatory model. But that said, I mean, it creates a lot of areas of uncertainty, and that's really kind of what we're going to get into today, is that some of these actions by the FCC really, again, set the stage for future proceedings. Some, drop rules right away on affected broadband providers, and so we'll kind of sort that out. You had mentioned the oral arguments took place. We're waiting on that decision. I think the conventional wisdom is that we should see something by April, perhaps, and that depending on the way things go, there's a pretty good likelihood that that DC Circuit decision will probably end up in the Supreme Court, depending on who wins, who loses, or if it's a mixed bag. Someone will likely appeal further. So I don't know if you have any questions at this point, but I'm going to start going into sort of the FCC's sort of mindset in terms of why they did what they did.
One quick question. Can you just recap the three parts of this really quick? The three things you mentioned?
Three parts of the order were, first was an order on remand,
Okay.
and that's the part that really responds to the Verizon decision, and also I think I omitted it. It also establishes the bright line rules. There's three bright line rules, which I'll get into. The general internet conduct standard of conduct. There's sort of a catch-all rule. And also lays out some of the enforcement provisions of those rules. So that's one, the order on remand. The second is the declaratory ruling, which was the piece that really that actually effectuated the reclassification of broadband internet access service as a Title II telecommunications service. And then the third piece is the forbearance order, which talks about the Title II application or forbearance areas, and we'll get into that so that we know what is sort of getting a green light and what is getting sort of a red light, meaning they're going to forbear, and then what maybe gets a yellow light, meaning they'll forbear now but might adopt in the future as a future rule. So
Right. Thank you for reiterating that.
Sure. So basically, the FCC's mindset here was that broadband providers really have, based on the record, the economic incentives and the technical ability to engage in practices that pose a threat to internet openness by either harming other network providers or edge providers or end users. And that they really sort of to bolster this virtuous cycle, and I think that's a term that was heard a lot and spread out a lot, particularly by Chairman Wheeler, that they really want to make sure that broadband providers aren't incentivized or that there's rules in place to prevent them from basically preventing edge providers and end users having sort of a free flow of traffic. And they basically acknowledge they have the incentive, they have the ability. So really it came down to the fact that broadband internet access service providers are the gatekeepers of the internet. And being the gatekeepers, that really is what it all boils down to. So one important definition to focus on here is what is broadband internet access service, because there's internet, there's connectivity, but this really focuses on a user's ability to access the internet, and that internet should be free and open. And I'll get into a couple of different sort of nuances here, because not everything that is online is necessarily broadband internet access service. They define it as, and you also see the acronym BIAS or bias. So if I refer to bias here, that's really what I'm talking about. But the order defines it as a mass market retail service by wire or radio that provides the capability to transmit data to and receive data from all or substantially all internet endpoints, but excluding dial-up internet access service. So, dial-up is not contemplated here. So this really contemplates and includes the exchange of internet traffic by an edge provider or any intermediary with the provider's network. And this will kind of get into, we'll also start talking a little bit about interconnection, but that'll be a separate component. But what it excludes, this definition of broadband internet access service, is what had been called a specialized service and then sort of also became known as non-broadband internet access service or non-bias. And that has been kind of an interesting little subterm or sort of an exception to the definition, because it really refers to these like services provided by a broadband provider that isn't necessarily directly affecting a customer's ability to access the internet. These are over-the-top video services that, though they may actually operate on the internet, are not considered the internet access service. And one example I can provide right now that has sort of been making the news is Comcast. They've introduced in a couple of markets this stream TV service. I don't know if you guys have been reading about it. Well, Comcast in their broadband offerings have actually started introducing data caps, 300 gigabit data cap. But what they're doing with this stream TV service, which provides sort of a suite of video programs, is that they're saying, well, they can provide that, and that a customer with this stream TV service can access these video programs at their own home using the internet, their laptop, their mobile device, and it does not impact or it does not take away from that 300 gigabit data cap. Basically, they're saying this is part of their cable service. It's not internet. It's not affecting their ability to access the free and open internet. And this is kind of a very interesting, loophole, depending on how you want to interpret it. But that's how some of the sort of the trade press are sort of viewing this as it's a bit of a net neutrality loophole. So I do think that this non-bias or specialized service is sort of an area that's going to blossom regulatorily speaking, provided this whole regime sort of gets upheld. But I think we're going to start seeing a lot of providers looking to that as sort of a detour or escape route to get around some of these restrictions that we'll be talking about.
Well, I've got a question. So it sounds like what Comcast is doing, and I'm just trying to throw this out there from my perspective, what they're trying to do is offer these services to their subscribers as part of their a la carte system. And if someone's not on that Comcast, because Comcast is NBC, so they develop their own content. So if someone's not on the Comcast, someone could pay Comcast for that service through any other provider, and that's how they're saying that this is not inclusive to broadband. Is that kind of, if the content's coming over their broadband connection, but because it's proprietary to their network and their customer base, they're able to say this is not internet access issues?
As I understand it, yes.
Okay.
They're trying to put these limits on how you can access this, the content in this particular service. And yes, so it could be a very narrow suite of programs based solely on business decisions on what who they want to include and exclude. But because they sort of mirror the way their cable TV service is provided, meaning it's still sort of an over-the-top service. I think they limit it to use within their home, and I don't I don't have that service, and I don't know all the details. But my understanding is that they've restricted it such that it is sort of part and parcel with their cable TV service, even though it runs on the internet. But it is not. It's separate from their their general internet access service, which is sort of a separate part of their offerings.
Really?
And on that, you can access anything, assuming they abide by the open internet rules.
And see, this all goes back, guys. Sorry for stopping you, Steve, but this all goes back to what is reasonable. The next question the next question I'd ask is, well, can I get that service without having internet service?
I think that you cannot.
So see that immediately once you say that, you have to have internet service to get this service. So how is that separate? And I understand where they're coming from. They're saying, it's only on my network. So in other words, if I wanted to have a video service on my network, I could exclude them from data caps if I had data caps. Even though I don't think the whole data cap argument is really a big thing. I think either the data, it's either data or it's not. But I don't think a data cap is a big argument. I'm more interested in finding out all the regulatory loopholes or what's going to happen whenever people are blocking specific websites or specific types of traffic because of various reasons, and just because they don't want them on the network, just because they think that that's going to cause more trouble than it's worth. Can they do that? That might be. Maybe ask you. Would you?
Go ahead.
Is that something that would be? The way I look at it right now is that those customers or those types of internet providers, most of these guys believe as long as they disclose it that they can block it or whatever. Do you think that's a good stance to take, or is this still really up in the air? We can discuss it left and right, but it's to me it sounds like everything's still up in the air because it wasn't defined well enough.
Yes, I do think at least as things may sort of fit potentially into this category of, I really should pick a consistent term, specialized service or non-biased service. That to me is still up in the air, and that's where I think that this sort of, like the Comcast example, really kind of might fit squarely in. We don't know yet. I think the FCC is kind of keeping an eye on it, but we haven't seen it or heard anything yet. And I do actually think, just to briefly touch on it, that the data cap is relevant insofar as that it incentivizes or at least influences customers toward that service. If you're with that cap, you're going to want to preserve as much as possible. And if you feel like, well, I can watch, and I don't know what channels are part of that service. I can either watch Game of Thrones on, my regular internet, or use, this other box or device, or, access it by this other app and not worry about my data cap. I think that's definitely going to push traffic in that direction. But this is actually a perfect segue into my discussion of reasonable network management, which is also, I guess, an exception, to the bright line rules that we'll get into, talking about blocking, throttling, no pay prioritization, is that sort of overarching at least two of these rules, is a carrier or a provider's ability to use reasonable network management. And I'll just read the definition just to get that out of the way. That it's a network management practice that has a primarily technical network management justification, but does not include other business practices. A network management practice is reasonable if it's primarily used for and tailored to achieving a legitimate network management practice, taking into account the particular network architecture and technology of the broadband internet access service. So, long definition, but I think you really hit the sort of the highlights of that definition in your discussion earlier, Dennis. Is that it has to be technical, and it cannot include a business practice. So, while I'm not going to answer that question about the customer who asked about blocking YouTube, I would wonder, what are all the reasons behind it? I mean, I think that will be relevant. I'm sure YouTube is carries a lot of heavy traffic on their network, but I'd be curious to know, and you mentioned it, why YouTube? Why not YouTube and HBO Go? Or why, it depends on, I think those reasons are all germane to that analysis. And no, we haven't necessarily seen all of this come into play yet, so it is definitely ripe for interpretation. Of course, nobody wants to be the subject of that initial interpretation, and we'll get into sort of the ways around it, and I'll probably use this word a lot, is that disclosure is, while not necessarily the solution, it's certainly what's going to get you in trouble if you fail to disclose.
So let's ask this question.
Yeah.
If there is a provider that wishes to block traffic, such as Netflix, and they disclose that in their terms and services, they inform all of their users that the terms and services have been updated. They give them, reasonable, 60 days to that this is going to change, yada yada yada, and then on such and such date, they basically block a service similar to Netflix. Now, they are blocking Netflix for a technical reason of that a significant chunk of network traffic that causes congestion on their network, it comes from Netflix. And by blocking Netflix, we will free up the network for other types of services that are not significantly, that each individual service is not individually significantly affecting the network. So the example we use is HBO Go or some of these other streaming services. The difference is that if my congestion 33% of the time is caused by Netflix, where these other congestions may be caused by 1 or 2%, I'm going to go after the big guy first because that's the biggest bang for my buck. I can block one website versus trying to manage a whole bunch. So that's the technical reason. Now,
allow the data to flow.
Right. But let's say that happens and they're disclosing it. Now, the big problem that I see is that the information that you just given, the description, unfortunately, is still vague. To whose technical specifications? To whose reasonable network management standards? Right? Now, is the FCC, so could that company go, hey, we disclosed this, and send a letter to the FCC or something and saying, hey, I need a ruling to make sure I can do this? Is that something the FCC is going to do, or are we just going to see some FCC complaint or 500 FCC complaints from this one ISP because they blocked Netflix, even though they disclosed it. And now, even though they disclosed it, the FCC is going to issue a fine and a ruling stating you can't do that, and here's why. Or are they going to say, no, you can't, or they can say it's been disclosed, therefore you shouldn't do this, but we're not going to fine you because we didn't rule on it. See, that's why I guess my question is
and are a legitimate reason to do it.
Well, who's legitimate? See, that's the problem. Is there's different interpretations on that. And right now,
ISP.
Right, but right now there is no dedicated place to say yes or no. And I guess my question is that these ISPs and these providers are not wanting to get caught in the crosshairs.
Right.
But yet we're not getting information from the FCC, rulings, or yes-nos from them. Is there a process with the FCC to ask that?
Yes, there is, actually. And all of the scenarios you raised about someone wanting to do this and perhaps test the waters, although I don't know who's exactly necessarily wanting to do that without being, pretty deeply pocketed in order to sort of insure against it. But
well, see, that's the problem. Is I know a number of people that are already doing this.
Yeah. So if someone wanted to offer a Netflix-free package, and it's disclosed because that's what it's called. It's definitely not clear whether that would fly, but if there is a mechanism where someone can definitely seek in advance an advisory opinion or a declaratory ruling to try to get as best an answer as is possible, that is certainly probably going to be a time-consuming and drawn-out process, but if it probably beats being, a target of the Enforcement Bureau's, efforts to tell the world how seriously they're going to be taking this. So, yes, there is a way to do that, and the reasonable network management standard is going to be determined on a case-by-case basis, which, yes, is what you were saying. There's no clear guidance, and unfortunately, this is probably something that is going to develop by precedent. So it will be, the violators and wrongdoers who will start sort of providing the, edges of what is and what is not permissible. So, yeah, if a provider really knows for sure that, they feel fully justified, based on technical reasons alone, that it's got to be this one source of content, be it Netflix or whatever, and they want to disclose that they're going to throttle or block, or it would be better to try to test the waters in a declaratory ruling or advisory opinion scenario rather than
so there is a process that they can try to go through. Whether or not that will be, will you get an answer in 30 days? Probably not. Will you get an answer in a year? Probably not.
It's going to be, it would be back and forth. It would be, you want to keep,
it'd be a while.
Depending on what you want to do, you got to keep things confidential because ultimately these advisory opinions are publicly available, and that's something that's people need to keep in mind. There definitely are mechanisms available, and the FCC, I think, is trying to encourage that, but I don't think you're necessarily going to see a lot of traffic on that until at least these rules or this order has some sort of certainty attached to it. So in the meantime, I wouldn't suggest experimenting too much. Unless you're ready for
the consequences. I want to make sure I point out this too is something that you said is actually absolutely, I would think, absolutely against open internet, which is a Netflix-free package. Because a Netflix-free package is a business reason, not a technical reason. Would that be not correct?
Probably, yeah. That's
you're discounting the service so that they don't use. I understand that, but I'm just pointing out that by you changing a package to not include something, that means that technically you can do it. You just are offering a different package that doesn't. And that would be a to me anyway, that would be probably a big no-no. But I guess
yeah,
let's.
No, I didn't say it was anything that. I'm just saying if this is something that someone wanted
Yeah.
to do. That's anyone's willing. Certainly welcome to make up any offering. But I would. I'm just saying if somebody wanted to attempt that, I wouldn't put it out on the market first.
Sure.
Yeah. No, and I think you're right. I think there's. The FCC is probably likely to frown upon such a thing unless. I don't know. Unless they can manage to justify it, but I will get into some of the bright line rules in more detail now, because
Yes, please do.
we do need to start talking about sort of the nitty gritty of this, and we have already. The three bright line rules. The first one is, of course, no blocking, and that is still subject to the sort of reasonable network management exception, but blocking is, of course, not a complete wholesale prohibition. I mean, there's law enforcement reasons for blocking. On the benign side, there's copyright infringing content, and maybe that's, maybe someone was put on notice that, someone is, Game of Thrones, I think it's the most pirated show. I think someone, a provider who's able to identify those streams can block that because that's not law-abiding, and then of course law enforcement, child pornography, that sort of thing, is allowed, and sort of the sort of lesser version of no blocking is no throttling, and I think this is something that we're going to see a lot more of, and we are starting to, meaning no throttling, meaning no impairment or degradation of lawful internet traffic on the basis of internet content, applications, or services, or of a non-harmful device, and again, subject to reasonable network management. Now, you had mentioned again T-Mobile's binge-on service, and I did just see very recently this sort of allegation that T-Mobile's optimization feature, is actually a throttling feature. And I don't give credence one way or another to sort of this claim, but that I think that it originally came about as as part of this binge-on service, which is again video service that does not take away from your sort of data buckets of T-Mobile's offerings. That initially got attention with what they were doing with YouTube, but then I think it's been revealed that all of the video that they're providing on this through this binge-on service is, allegedly being throttled, that it's downgraded and then kept at, I think, is the equivalent of like 480p, something like that. But again, I'm not completely familiar with either the service or these allegations, but I think that that it's certainly getting attention within the context of throttling, and that's something that again we'll sort of keep paying attention to and see where it goes and see if it actually does test the limits of the FCC's willingness to accept certain activities. That
was the bright line ruling the 2010 thing that I think all ISPs can say, yeah, that's pretty reasonable.
These bright line rules actually were established in this current open internet order. The ones in 2010 were a bit different. For instance, the third one we're going to get to is no paid prioritization. That didn't even exist. Blocking was in the first one, and I don't remember exactly how they were presented previously, but I think there was. I'll have to look back, but there were about 3 or 4 other, the equivalent of bright line rules. I think there was a no discrimination rule, but I'll have to look back. Throttling may have been in that as well, but the way they've been introduced now is these 3 bright line rules. This is a new. They're sort of being presented newly as these 3 bright line rules. And yeah, the third one, as I just mentioned, is no paid prioritization, and that really came about, pretty recently within the sort of latest go round of comments, and that's defined as management of network to directly or indirectly favor some traffic or other traffic, including through traffic, shaping, prioritization, resource reservation, etc., in exchange for monetary or other consideration, or to benefit affiliate. Now, there is no reasonable network management exception to this rule because it's all based on a business decision, since it's for in the exchange of money or other consideration. So no paid prioritization is going to be also potentially tested, possibly also within some of these suites of channels, depending on how they're viewed. But there is a potential for getting a waiver of this rule. The FCC did say they will entertain waiver requests, but they would have to sort of present exceptional circumstances based on significant public interest benefit that would not harm the nature of the open internet. So it's a high bar, but it is technically available. And so now that the order has presented those three, there's sort of the catch-all rule, which you might have heard as the Internet Conduct Standard, or the No Unreasonable Interference / Disadvantage Conduct Standard. And it's also subject to the Reasonable Network Management exception, but it's basically saying, we don't want providers to unreasonably interfere with or unreasonably disadvantage that sort of, again, relationship between an edge provider and the content with the end user. So it's sort of there to be sort of a safety net. It's not exactly blocking, throttling, or pay prioritization. They still want to be able to bring someone in, question them, and it's a bit problematic in that the standard is not very well articulated, but they know they want to be able to do something. So that's and I think that is actually one of the areas, from what I understand in the oral arguments, that we'll probably have some difficulty in getting that affirmed, because there is a bit of a problem with the notice element of getting that standard clearly articulated and have everyone understand really what it means, when in a sense the FCC really also doesn't quite know what it means. So at this point, now we've talked about the three bright line rules, the conduct standard. I'm going to get a little bit into the disclosure rules. These are actually first established in 2010, and they were actually upheld by the Verizon court. And what the FCC has now done is enhanced those rules. So, for instance, and these rules actually now pertain to sort of three categories. One is your network practices. Two is the performance characteristics of your network. And three are the commercial terms of your broadband offering. So when these were first laid out, they were upheld because they were sort of found to be properly, I think, grounded in existing FCC authority. But now, with these enhancements, they are certainly a lot more detailed and certainly more difficult, because so the means of disclosure, how to disclose them, for instance, in 2010 meant a prominent display on a website and any point of sale. But now there's the enhancement to how to make your disclosure includes, and I'll just sort of read this because it's pretty convoluted, is a mechanism for directly notifying end users if their individual use of a network will trigger a network practice based on demand prior to a period of congestion that is likely to have a significant impact on the end user's use of the service. If nothing exactly comes to mind on what that means, it's probably because it really isn't exactly clear. Imagine even from a mobile wireless perspective, how you're supposed to notify, a customer, maybe by text message or something that that basically a network practice is about to be triggered based on a particular demand prior to a period of congestion that may impact their use. It's pretty difficult, and considering the size and sort of money constraints that our clients face, being rural, small rural businesses. This is definitely something that sort of gave us pause. And I'll even get into some of the other enhancements a little bit of these disclosure rules. So like, for instance, in the network practices, now they're supposed to include practices that are applied to traffic associated with a particular user or user group. And, not everyone is, inspecting, traffic. They have to provide the purpose of the practice, which users or data plans may be affected, triggers that may activate the practice. And a lot of our clients don't necessarily have sophisticated network management practices like these. So there's been a bit of question as to sort of the reasonable applicability of these enhancements to all providers equally, which isn't to say there isn't concern about the customer experience or disclosures made to customers, but for a lot of small businesses, I mean, the existing disclosure requirements were pretty sufficient. And even, the enhancements sort of go on, talking about application-specific behavior, device attachment rules, various security practices. And the next category of disclosures, performance characteristics. Now that it used to include expected and actual speeds and latency, and the suitability of the service for real-time applications like VoIP. Now they've included packet loss. Now they've included disclosures reasonably related to performance that a consumer would likely experience in their geographic area. Now, again, for a mobile consumer, that's going to be, how do you tell someone, exactly what their experience will be, when that device can really be anywhere at any time. So there's certain considerations that came into play here. And I think you guys may know that these enhancements to the disclosure rules, those are the ones I'd mentioned earlier on that are still technically not effective yet because they haven't been approved by OMB. But there's also right now a temporary small business exemption from those enhancements. And that was actually something that was an ongoing proceeding earlier this year. And just before Christmas, the FCC's Consumer and Governmental Affairs Bureau was required to make a decision on whether this small business temporary exemption would be made permanent or not. And what they actually did was they decided to sort of punt until next year. They temporarily extended it by another year, and they basically said, we are not going to make a decision until we've sort of completed until they've received OMB approval, have taken a look and completed the Paperwork Reduction Act processes, and then that basically would be decided likely by the full commission in about a year's time. And one of the things they've done is that they also kept the small business threshold at 100,000 or less broadband connections. So that's sort of one little takeaway from that order. And
So, some practical applications for the listeners here. What are you recommending in the industry that you represent, the rural telephone companies out there? You mentioned disclosure, and I know you can't offer any legal advice, but at a 30,000 foot level, what could our listeners do now to get ahead of the curve, as in disclosure, if they so choose? What are you recommending to your industry?
They absolutely need to comply with the 2010 transparency rules, and that's something that there's several advisories that the FCC released on how companies can do that, and those rules have been on the books for several years now, and so we haven't really seen any well, actually, we did see one significant enforcement action on disclosure, and that was AT&T actually got dinged a while back, actually not too long ago, for not properly disclosing some of their throttling practices. And so what we would absolutely recommend is, making sure that your current disclosures as they relate to commercial terms, meaning like your monthly charges, usage-based fees, early termination fees, the performance characteristics, I mentioned speeds, latency, and network practices. All of those really need to be current, well displayed, so to speak, at point of sales and on your website. And then as for the enhancements, because they're not in place, there really isn't anything to do at this moment, but just sort of to keep monitoring any developments. I mentioned the small business exemption. That's something to keep paying attention to, and as needed, possibly participate in any future proceedings. But there's also a bit of a safe harbor that is being worked on at the FCC as it relates to the format of these disclosures. And the content of that was just released, I think, in either late October or early November. And the FCC is still needing to adopt that and sort of finalize it. But that's what they sort of been calling the nutrition labels of broadband. So that's something to pay attention to. And, to the extent that, maybe a lot of our clients or WISPs might not be exempt, that small business exemption could feasibly not be adopted or made permanent, then do pay attention to how to get all the enhanced disclosure requirements included as part of yours. But in the meantime, there's a bit of a wait and see, but definitely pay attention to the 2010 rules. And that's actually, and like I said, there's advisories and guidances out there from the FCC that so yeah, that's the disclosure rules, and I'm going to get enforcement aside of this because it's and we mentioned earlier that you can get an advisory opinion before acting, and that is something to keep in mind if anyone has a controversial idea or business idea that it's much safer to go that route. And that as I don't know what you guys have heard or seen, but now that they haven't forborne from enforcement, this could feasibly and kind of has been opening the doors to some new types of complaints. And this was something that was briefly discussed at the panel, is that now there are opportunities for customers or edge providers or whoever feels aggrieved under these rules to file either an informal or formal complaint. And that you may start seeing complaints coming out of the woodwork that are couched as open internet or net neutrality violations, but in fact are actually not, because there's a lot of sort of misinterpretation of these rules or misunderstanding of what is meant. And we've actually had one client who received an informal complaint accusing them of violating the no blocking rule, when really what it was is a customer who actually just wanted to resell their internet service in a multi-dwelling unit scenario, and that was a violation of their the terms and agreements of the service. So it really wasn't blocking; it was just it was a completely separate issue. But that's the kind of thing you may see as sort of coming out as appearing to be an open internet complaint. So I still haven't even fully gotten into some of the other areas here, but I know we're kind of at a little after 1 o'clock, so I can keep going. Is that how do we want to proceed?
It's solely up to you. What do you think, Dennis?
We'll probably have to start wrapping up here a little bit. We don't want to keep everybody forever. Obviously, we can always have you back on and chit-chat more about all these issues. I think there's lots of great information here, but at least this is someplace we can get started. You know what I'm saying?
Right. Yeah, no, this is definitely ripe for continuing conversation. And I mean, in terms of starting to wrap up and looking, I guess, ahead at what's to come, obviously all of this is fairly contingent on the DC Circuit's opinion, to see what's affirmed, what's upheld, what, maybe gets sent back to the FCC on remand. But essentially what we're potentially looking at here is, as you know, is that the FCC kind of proposed a light touch regulatory framework. And I think we're going to, assuming that some of this stays, and I think, my suspicion is that we could possibly see the order affirmed, at least for fixed broadband, and that I think there's a bit stronger case for mobile wireless broadband to maybe get sent back or overturned, but we'll have to see about that. But trying to move forward, there are areas where I think all broadband providers will need to start paying attention. One of these areas is privacy. I know this is an area that our clients are sort of fully ingrained in, as they've been regulated pretty heavily with respect to customer privacy. Now, the FCC's privacy rules are specifically written for telephone service, and in some cases cable service, so really depending on the service itself. And they are working on a new proceeding that is supposed to be launched any minute now, or at least in the next month or two, on sort of redefining privacy for broadband. You might know it as CPNI, or Customary Proprietary Network Information. And actually, in an interesting case that, or enforcement action that just came out, the FCC just issued sort of its first enforcement action against a cable company for being hacked, and those hackers had access to customer personally identifiable information, and that was against Cox. And while that was not a broadband case, it certainly could have easily become one, because most cable providers are also providing internet. And so I think we'll start seeing that come into play as the new privacy proceeding gets underway, and we should be seeing that soon. And I think one area that we talked very briefly about just before the show is that if this order is upheld, one potential victory for WISPs that is a beneficial area is that the Title II reclassification affords you more rights and protections with respect to pole attachments. That it should or is aimed at sort of stabilizing rates for pole access, and the order is pretty expressly and sternly warning of owners of poles and conduits and rights of way not to misinterpret that ruling as a reason to raise any rates to provide pole access. So that's actually something that everyone, well, particularly WISPs, particularly stand to benefit on if this order should be affirmed.
Right.
And well, those are some of the biggest ones right now, and I can just sort of open it up to any questions you have, or if you wanted to talk about anything else in particular.
No, I think you've hit all the points of the presentation the panel gave at Wispalooza. Very important stuff. So what I'm gaining here is, as takeaways for all the people that listen to the show, is look into the 2010 transparency rules, get some sort of privacy statement on your website. But I find it kind of interesting that the FCC smacked down Cox for being hacked when the federal government itself, the OPM, got hacked to the tune of 30 million people, are CIA people been hacked by the Chinese government, and the FCC didn't smack them down.
Well,
I just find it kind of their irony there.
Well, no, yeah, it's that irony isn't lost. But this is definitely something. It's an area that's only going to get busier, unfortunately. I mean, we've seen more and more of these hack cases, and so yeah, there's a special place for this type of activity in the FCC's rules, and so it's definitely an area you're going to have to get more and more familiar with, assuming this is the road that everything is going down.
All right. Well, I want to thank Bob Silverman for being on the show today with Bennet Bennet. They're out of Maryland, and he represents another industry, but dovetails rather nicely into what we do here at WISPA. And like I said, Bob was at the WISPALooza and gave us valuable insight and gave us some more valuable insight today. So I hope you've all have gleaned something new from our conversation today. So Dennis, you got any further questions or any more comments?
No, I think we're really good. There's a lot of great information. We'll just have to keep going from there.
Exactly.
Before we probably go though, Bob probably needs to hit up any of the how customers or how our listeners can get a hold of them if they need some advice.
Yeah, Bob, can you throw that out there?
Sure. Yeah, you feel free to send me an email. I'm our website, our firm's website is www.bennetlaw.com. That's BENNET, so 2 N's, 1 T. Or shoot me an email. I'm at rsilverman@bennetlaw.com. Again, 2 N's, 1 T. So yeah, that's. Or if anyone wants to give me a call, contact me the old-fashioned way. You can give me a call. 222-551-0053.
Well, this has been a really good show. I appreciate you again, Bob, for being on the show, and hopefully we'll see you with America.
Thank you both.
All right, Dennis, wrap us up.
Thank you for listening to ISP Radio. We hope you've gained new insights and additional wisdom in our industry as well as your business. Please remember to visit our show sponsors via the links on ispradio.com. If you're interested in becoming a show sponsor, contact us at sales@ispradio.com. Now go out there and push those packets as fast as you can. Good luck and Godspeed.